Well, friends, Judge Aileen Cannon has slowed Donald Trump's federal prosecution in Florida to a crawl. Or maybe she's just brought it to a complete stop. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Trump appointed Judge Aileen Cannon, who is presiding over Donald Trump's federal case down in Florida, the case in which Donald Trump is being prosecuted for unlawfully retaining classified documents, obstructing justice, and violating our nation's espionage laws. Judge Cannon held a rare hearing in the case. And now she has all but brought the case to a grinding halt. Judge Cannon has no business presiding over this case. We, the people, deserve better. We deserve a fair, independent, and impartial judge. Let's look at some of the new reporting. This from CNN. Headline, Florida hearing in Trump classified documents case devolves into shouting match. And that article begins, during a marathon day of proceedings in the Mar-a-Lago classified documents case, a morning hearing in front of Judge Aileen Cannon devolved into a shouting match amongst the attorneys, and the afternoon series of arguments prompted the judge to wonder if the legal nuances of the case may be too difficult for jurors to understand. What the hell does that mean? The prosecutors brought a case against Donald Trump. They're enforcing the laws of our nation. In a very real sense, we the people, the American people, are the victims of Donald Trump's crimes, including espionage offenses that undoubtedly did real and perhaps lasting damage to our national security. And a federal judge says, you know, I just wonder if the jury is capable of even deciding this case. What with all the nuances? What the hell does that mean? That's not the kind of language we typically hear from judges. I've never heard language like that in the 30 years I prosecuted cases in military courts and civilian courts, in federal courts and local courts, in trial courts and appellate courts. Judge Cannon has no business presiding over this case. And I'm not even going to take time discussing the shouting match where some of the defense attorneys were making all of these absurd claims of prosecutorial misconduct that the prosecutors said, and I quote, are absolute garbage and untrue, not the kind of language you typically hear from federal prosecutors in court. But I'm going to set all that aside. And I want to turn to some more of the reporting, because what I want to do, friends, is take on two of the legal issues that the defendants, two of the three defendants, Walt Nauta and Donald Trump, Carlos de Oliveira is the third defendant, some of the legal issues that two of the defendants offered to Judge Cannon, suggesting that these are actually viable legal issues. And because Judge Cannon has to address these legal issues, she basically, slows the prosecution down to a crawl. And I want to take on those two issues. Let's shift over to some new reporting by the Associated Press. Headline, Judge in the Florida Trump classified documents case will hear more arguments on dismissing charges. And that article begins, prosecutors and defense lawyers in the classified documents case against former President Donald Trump are due in court Wednesday for the first time since the judge indefinitely postponed the trial earlier this month. Let me say that again. She indefinitely postponed the trial. She asked the parties, the prosecutors and the defense attorneys previously for proposed trial dates that worked for them. Prosecutors, Jack Smith, said July 8th. Defense attorneys for Donald Trump and his co-defendants said August 12th. So August 12th would have been a no-brainer of a trial date. That's the date that was offered by the defense. They said they could do it on August 12th. Judge Cannon said, nope, not July 8th, not August 12th. In fact, I'm setting no trial date. Judge Cannon should not be presiding over this case. Let's go back to the AP article. The case, among 4 criminal prosecutions against Trump, had been set for trial on May 20th, but Trump-appointed U.S. District Judge Aileen Cannon cited numerous issues she has yet to resolve as a basis for canceling the trial date. I've got to interject again here, friends. She has just taken her time resolving these issues, and now she cites the very delay occasioned by her sloth and neglect, if not incompetence and nefariousness. She now cites the delay that she caused as a reason she can't even set a trial date. Judge Cannon should not be presiding over this case. Back to the AP article. On Wednesday, Cannon was scheduled to hear arguments on a Trump request to dismiss the indictment on grounds that it fails to clearly articulate a crime and instead amounts to, quote, a personal and political attack against President Trump with a litany of uncharged grievances, both for public and media consumption. Prosecutors on special counsel Jack Smith's team, which brought the case, will argue against that request. Trump, a Republican, is not expected to be present for the hearing. Okay, friends, now let's turn to two of the issues, two of the motions to dismiss the case. One that was filed by Walt Nauta, one of Trump's co-defendants, and the other that was filed by Donald Trump himself. Now, mind you, they filed these motions saying that the cases against them must be dismissed in their entirety. They can't be prosecuted. Let's take on Nauta's claim first. Walt Nauta's lawyers claimed that Nauta is the victim of what's called selective prosecution. Now, first of all, the doctrine of selective prosecution is a thing, right? There is a legal doctrine known as selective prosecution. Let's talk about precisely what it is. So the leading case regarding selective prosecution, the leading precedent from the Supreme Court, is a case that arose in the aftermath of the Vietnam draft, the Selective Service. It's a case called Waite versus the United States, W-A-Y-T-E. And here's what it involved. During the draft, back in the Vietnam era, there were more than 670,000 people who failed to register for the draft or who refused to register for the draft. And it was a crime. There was a statute on the books that said if you fail to register for the draft, you're committing a federal offense. And so, after the Vietnam War ended, the Department of Justice had to decide, well, what do we do with the more than 670,000 people who failed or refused to register for the draft? And they decided that they would prosecute some of them. Out of the more than 670,000 people who didn't register for the draft, guess how many the Department of Justice prosecuted? 13 people. Just 13 out of the more than 670,000. And those 13 defendants filed motions to dismiss their cases claiming selective prosecution. How in the world can you only prosecute 13 out of 670,000 who committed the same crime. Sounds like an argument that might have some merit, right? Well, the Supreme Court decided it really doesn't have much merit. And they announced a test, and it was a test that set a very high bar for a defendant to prove that he or she was being selectively prosecuted in a way that violated the Constitution. And the test essentially is that the defendant would have to prove that the prosecutors not only discriminated in who they decided to prosecute and who they decided not to prosecute, but they announced that it would have to be discriminatory in its effect. In other words, some people unfairly got prosecuted and others didn't. And it would have to be discriminatory in its purpose. In other words, you'd have to prove the prosecutors intended to discriminate by singling out one person or another for prosecution while foregoing prosecution of others for the same crime. And in the Waite case, the Supreme Court said the defendants showed neither discriminatory effect nor discriminatory purpose or intent by the prosecutors. So the courts rejected all of those motions to dismiss. If you're interested, one of the reasons DOJ decided to prosecute these 13 is they were among, I think, some of the most vocal proponents of people not registering, people violating the federal law, and they were urging people not to register, basically urging them to commit crime. And for various reasons, the Department of Justice obviously couldn't prosecute all 670,000. So they chose these 13 as they were the ones who, for some factual reason, were most worthy of prosecution. And the Supreme Court said that's just fine. Walt Nauta being selectively prosecuted? What? Because tons of other people were criminally helping the defendant, Donald Trump, unlawfully retain national security information and obstructing justice by moving boxes around and hiding them from the FBI and from the DOJ and from the grand jury subpoenaed requiring their return? Because there are, so many other hundreds or thousands of people who were also criminally complicit with Donald Trump doing the same thing. It's an absurd claim by Walt Nauta that he's being selectively prosecuting. I think the fact that he offers is that, well, other people may have touched the boxes. Come on, sport. It's a frivolous motion to dismiss, a baseless motion to dismiss. I would go so far as to say it could be called a bad faith motion to dismiss. So what would a judge, a normal judge, a fair, impartial, and independent judge do with a motion like that? Well, she would read the motion. She would read the prosecutor's reply, relying on the case law, including the Supreme Court precedent on the issue of selective prosecution, and she would deny the motion on the papers, and she would do it promptly, like literally within days of the prosecutor's opposition being filed. Done. Let's move on. We need to set a trial date. We need to move the case forward in the direction of a trial. But no, not Judge Cannon. Let's just at a leisurely pace, set this thing sometime in the future to have motions hearings, have oral arguments, and then I'll take lots of time, maybe weeks or months, to actually resolve something that is a BS motion, a frivolous motion, right? A bad faith motion. Could have been resolved in an instant, but instead it lingers for months. That's not a judge acting in good faith. That's a judge who is proving over and over again that she has no business presiding over this case. Let's now turn to Donald Trump's motion, which is perhaps even more frivolous than Walt Nauta's selective prosecution motion. And it was mentioned in that AP article that I read a moment ago. Trump requested to dismiss the indictment on grounds that it fails to clearly articulate a crime and instead amounts to a personal and political attack against President Trump with a litany of uncharged grievances, both for public and media consumption. Friends, That is not the language of legal motions, of federal court filings. What that sounds like is an angry, unhinged tweet. That's not a legal argument. That's a bunch of PR blather. And claiming that the indictment in the case, which chapter and verse sets out each and every alleged crime that the grand jury indicted Donald Trump for, in many ways, it's kind of a standard indictment. It is constructed the way federal indictments are constructed every day of the week, 100 times over, and have been for decades. There's no deficiency. There's no infirmity. There's no basis to file a motion to dismiss the indictment because, gosh darn it, it just criticizes Donald Trump too much. You know what a judge would do with that? I have to tell you, there are defense motions that are so frivolous that sometimes judges summarily reject them without even asking the prosecutors to file a response or an opposition, because it just kind of falls under the weight of its own frivolity. It's so bad. It's so ridiculous. It's so unsupportable and unsupported by any case law. But Judge Cannon had the prosecutors file an opposition, and the minute she got that opposition, she could have read it and rejected the motion to dismiss on the papers. But no, need to take a lot of time, have a lot of hearings, sometime well off into the future, then maybe someday I'll get around to deciding the issue. Judge Cannon should not be presiding over this case. We, the people, have a dog in this fight. We have an interest in a fair, just, reliable outcome, right? And the only way we can be assured of a fair, just, and reliable outcome is if a fair, independent, impartial judge is assigned to preside over this federal prosecution in Florida. Now, friends, about a week ago or so, I did a Justice Matters video that has a step-by-step tutorial on how anybody who's interested, can file a judicial complaint form against Judge Cannon. And I will put a link to that video in the description of this video. And if I knew how to put one of those little buttons on the screen at the end of my video so you could just click on it, maybe I'll try to get somebody to help me with that. But you may have heard me say that, on the computer front, I am incompetent. I can't even spell IT. But one way or another, I'll try to direct your attention to that earlier video that I know a lot of folks used, and they followed the step-by-step instructions, and they submitted. They mailed, which is how you have to get it, to the 11th Circuit Court of Appeals. That is the court that has supervisory responsibility over Judge Cannon and those in that federal district. A lot of people took advantage of that step-by-step video, and they submitted those judicial complaint forms, which any member of the public can submit. If you feel like Judge Cannon's impartiality might reasonably be questioned, which is the federal standard that requires her to remove herself from the case, you can go ahead and file one of those judicial complaint forms. And I would urge you to consider doing it. You know why? Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.